want the perception to be anything different.
Just checking to see if anybody can hear me.
I can.
Hey, Bart, what's happening?
Hey, Bruce, how are you?
Good, sir.
And for the parties information that are all live on this Zoom link, we are also being broadcast live in the chambers, and the public will listen in here. We're also being broadcast, I've already said live on YouTube, but in both locations. But the majority of the participants, both the attorneys and the hearing officer, are all on Zoom. So for the public's consumption, we're in person in the chambers.
Okay, I think everything on our end's good to go.
Let me just verify that you can hear me. Am I coming through?
Yes, for me.
Thank you.
And yes, Mr. Collins, Chambers, yes.
Thank you. Good morning. Today is Wednesday, the 18th of September, 2024. We are convened in an appeal hearing held under the authority of the Grant County land use ordinances. My name is Craig Call. I'm the appointed land use hearing officer for Grant County. And let me, first of all, allow those that are here representing the parties who will be participating in the hearing to introduce themselves. And then I have a few comments to add.
Bruce Beard on behalf of the appellant.
Bart Coons on behalf of the appellee.
Stephen Stocks, Grant County Attorney on behalf of the appellee.
Thank you. Let me just explain that I've had no information about this matter other than what I have read in the briefing and the materials that were submitted. I did have occasion to review the Grant County General Plan, which was not given to me in its full 209-page glory, but I did access through the links that were included in the briefing. I've had no conversations outside the one hearing that we held earlier in August or June, I guess it was. And so all I know is what I read in the briefing and what I've gleaned from the general plan. This process is governed by the Grant County Code. And what that provides is that a hearing on a land use appeal is basically to be held in a public setting and properly noticed, as I see this has been. It is a de novo hearing. What that means is that I can look at all the information that the parties wish to present about the issues, and I'm not limited to what was presented to the county commission. In fact, I don't know all the details presented to the county commission because this is not a record review. I don't look at the record before the commission. but I do review materials submitted by both the county and the property owner, in this case, the advocate. I don't mean property owner, in this case, the advocate on the appeal is a special service district. So the county ordinances do not provide for public comments, but this is a public hearing, so the public can observe, and it obviously is being recorded and will be available for anyone who wishes to review it or observe it. I also looked at the staff reports that were prepared on this matter. One was dated April 11th, and one was May the 1st. Again, those were referred to in the briefings, and the minutes of the commission hearing. Let me, before we start, congratulate the advocates. Well briefed, 54 pages of very intense analysis of all the issues related to this. It appears that from the stipulation of the parties that we are basically concerned with one issue. The matter is a conditional use permit, and basically what the county code provides and the state law provides is that it should be approved if it's consistent with the law, and if it's if reasonable conditions can be imposed to mitigate the reasonably anticipated detrimental effects of the use. So in this case, the proposed use is a public utility, a water and sewage district with facilities located in Grand County, but outside of course, the city limits of Moab. So again, thanks for the briefing. That's been very helpful to me. I probably don't need to say any more, and would invite those who speak to make sure they kind of explain the context of this in a way that those from the public that haven't been involved in all this process might also be able to understand where we are and where we're going with this. So with that, in the normal procedure here, we allow the appellant, the person who's challenging the decision of the county commission, to speak first. We'll also invite those representing the county to speak, allow the appellant to respond, and if necessary, this doesn't have to be that formal. We can conduct a conversation on these issues, but certainly want to make sure that there's time allowed for anything that needs to be reviewed to be considered. Any questions or comments about any of that at this point?
Just one question. Do you prefer to be addressed as Mr. Hall or the hearing officer or Your Honor?
My last name is Call, Mr. Baird.
I assume so, Mr. Call. I just wanted to be careful because it's always weird. I'm always used to saying Your Honor, so I will try to say Mr. Call.
You're better off not using the term Your Honor. It's prejudicial if you do.
Then I won't dishonor you by saying Your Honor, Mr. Call.
Okay, thank you.
Mr. Call, I do have one question for you, and that is, I just wanted to confirm that we did submit the record, even though it's not a record review. And I just want to confirm that you did receive that. The master plan was a part of those documents, I believe. So I just want to make sure that you got that.
Yes.
Okay.
Yeah, the general plan was, and I actually spent time reviewing it today, and I'm going to cite to a base number from it. So we'll go that way.
Yeah, and I did review the minutes. I did review the staff reports. I didn't look at everything else in the record. Again, it's not a record review, but yes, I did receive the record and appreciate that being, that of course then makes it part of the record of this decision as well.
Perfect.
Mr. Baird.
Thank you, Mr. Hall. As you indicated, it's my practice not to read my brief to you. I know of your, from prior dealings, I know of your extreme level of due diligence. And so I'm going to assume that you've read everything, and I agree with you about the quality of the briefing. I think Mr. Coons, on behalf of the county, and Mr. Stocks did a great job of phrasing their argument. I would also agree with you that this really is not just one issue, but I think it's one sub-issue. When you read the county's brief, the entire argument of the county comes down to their policy, Romanet 8. Do not extend community, and pardon me for reading it to make sure I got it right. Do not extend water and or sanitary sewer services outside the urban service area service level 1 unless consistent with an adopted urban growth strategy or for public safety reasons as determined by the Planning Commission and the County Commission. As far as I can tell, that's the only question. Now, there's a whole bunch of sub-questions embedded in that as we parse that. But I want to start off with something that actually I haven't briefed, because sometimes I come up with new thoughts as I'm preparing for oral argument. And this is a statutory argument I'm about to make that I apologize for not briefing, but I think it's about as fatal to the county's position as anything I can think of. And that is, we all know on this call, and anybody who practices land use knows, that section 506, 1727A, 506 1A requires compliance of the conditional use permit application with the, quote, objective standards of the county. I would submit to you that the phrase in Romanet 8, as determined by the Planning Commission and the County Commission, is about as far away from an objective standard as you can possibly get. It is almost, by definition of the word discretion, a subjective standard, and therefore Romanet 8 cannot be a basis for denying the CUP, because that would not be objective. So again, I apologize for not briefing that. It just slapped me silly across the face this morning as I was, for the 15th time, reviewing everything and went back to the bases. And frankly, what triggered it, and I'm not trying to curry favor with Your Honor, but I reread your.
Oops.
I'm sorry, Mr. Call. Yes. Oops, yes. I'm not trying to curry favor with you, Mr. Hall, but I reread your article from the Land Use Institute, and the word objective standards just jumped out at me. And I then recalled that, frankly, the word objective standards is put in the code basically because I screamed and hollered to the legislature a great number of times that subjective doesn't get you there. So the word objective was added to the code relatively recently, as you know. So that's the first issue, that it's simply not an objective standard. But let's assume for the moment that you can go beyond that. Then the question is the proposed CUP within an adopted urban growth strategy, whatever the heck that word means? And let me start with the whatever the heck that word means, because that again proves that it's not objective. Because you take a look at my friend Mr. Kuhn's brief, and it's written, with all respect, in a form of what I call planarese at some parts. In other words, it's a whole bunch of vague language that people hope that if you throw enough vague language at something, the combined weight of the vagueness will somehow make it clear. But Mr. Kuhn's cites on page 9, for example, that it must be consistent with an urban growth strategy, but we don't know what an urban growth strategy is. So you go to page 10 of his brief, and it reads, although the general plan does not define an urban growth strategy, the plan makes clear that it is distinct from a zone. Although zoning can implement strategy, a zone is not itself strategy. And then it goes on to say that the phrase growth strategy, urban growth strategy, is a term of art used in codes across the country and internationally, meaning a, quote, policy-driven strategy for handling anticipated fast growth in the locality. I have no idea what the heck that means, but let's assume it means something. It's certainly not objective, it's by definition subjective. But now let's talk about what it is. It can only be something like the following. It can only be something adopted in the future, titled an urban growth strategy. So theoretically, the county could come out and go, okay, we are adopting an urban growth strategy. Well, they haven't done a specific urban growth strategy document at the moment. So I guess their position is that by refusing to adopt an urban growth strategy titled, quote, urban growth strategy, they can effectively prohibit all development in the county that is not currently served by utilities, because by definition, all future development not currently served by utilities must require new utilities. So they have effectively downzoned and restricted the ability of the entire currently unserved county to its open space forever, unless you come back in and beg for forgiveness or beg for permission by getting some approval from the county. So they've effectively downzoned the entire county, the entire undeveloped portion of the county to open space at the moment. So that's one option, is they could downzone by inaction. The second, I suppose, is they could adopt a document titled, quote, urban growth strategy, and simply say that they're downzoning the county to nothing. Or they could do what we think they did, which is adopt, as part of this general plan, an urban growth strategy for this parcel in particular. And that urban growth strategy is found on page 147 of the master plan, which is Bates number 1712, which shows this property as highway mixed use. They adopted it. Now, I understand they're now saying, oops, King's X, timeout, we really didn't mean it. That's just a remnant. It's an accident. We're sorry. Please ignore it, etc. Well, as we cite in our reply brief, they can't do that. The law in Utah, and I've had this more than once, you can't manufacture legislative intent by denying the existence of reality. This is not one of those see no evil situations. Their document says that the future land use of this property is highway mixed use. If I may take a second and share my screen on that document, I will bring it up and you can see it, because I know you've seen it, but let me share it anyway, if I may. Yeah, I'll share the entire screen. Let me take you down, I'm doing it the quick way rather than the easy way, but I assume you can see this map, Mr. Hall?
Yes.
Okay. This is titled Grand County General Plan 2030. It's hard to be more explicit than that. It says, it's page 147 of the general plan, down where my cursor is. You will see over here on the left the grayed out property in question, and you will see that it's designated under the legend as highway mixed use. And the title here says future land use plan designations. I am not quite sure how you can be any clearer than that about how this property is an adopted urban growth strategy. I guess it doesn't use the magic words urban growth strategy, but it's adopted contemporaneously with the requirement for an urban growth strategy. At a bare minimum, this document that requires, excuse me, I'm trying to get back to my screen here. There we go. At a bare minimum, given the ambiguity requirements of interpretation, which we're going to discuss in just a second, that master plan adopted contemporaneously certainly constitutes an urban growth strategy. Now we get to the argument, and I understand Mr. Kuhn's need to twist the logic around. But at some point, the county's brief claims that, well, you don't have to apply or you can't apply the ambiguity requirements of 404 to a general plan. As we point out in our reply brief, that's rather inconsistent. So it's illogical. What 404 says, as we all know, is that if there's any ambiguity in a land use regulation, then it has to be construed in favor of the applicant because land use regulations are in derogation of the unfettered right under the Utah Constitution to use private property for whatever you want to do with it. The county's position is, well, it's what I'm going to call schizophrenia. It's this. Well, it's not really a land use regulation because we adopted it by resolution, not an ordinance. And 404 says land use regulation, so it doesn't apply. So somehow a document that is vague and advisory by its very nature can be construed as a mandatory document under 406, but it's not subject to the 404 requirements of construing ambiguity in favor of the applicant. That makes literally no sense. I'm tempted, and I will, Mr. Hall, do what I usually do in this situation and quote some famous person, otherwise known as Humpty Dumpty. And this is from Lewis and Carroll's Alice in Wonderland. And the quote reads, "And only one birthday present, you know, there's glory for you." That's Humpty speaking. "I don't know what you mean by glory," Alice said. Humpty Dumpty smiled contemptuously. "Of course you don't, till I tell you. I meant there's a nice knockdown argument for you." "But glory doesn't mean a nice knockdown argument," Alice objected. "When I use a word," Humpty said in a rather scornful tone, "it means just what I choose it to mean, neither more nor less." "The question is," said Alice, "whether you can make words mean so many different things." "The question is," said Humpty, "which is to be master. That's all." And what the county is trying to say is we get to use utterly vague phrases with no definition, and then we get to tell you what they mean. And you don't even have the temerity to ask permission to have the temerity to ask what something means. We're going to tell you. We are going to be the master, even if we just made it up, which goes back, as I said, to the distinction between objective and subjective standards. They don't just get to make it up. They don't get to say, well, this general plan is just advisory, so you don't have to construe it strictly against the county, but it's mandatory because you have to 100% comply with it because otherwise you're prohibited. You cannot have it both ways. That's the definition of schizophrenia. And that's what the county's argument is. It's pure schizophrenia. So we'll move on from there. And again, I'm trying to, as I always do, try to not repeat my brief because I think we did a great job of briefing. I do want to talk briefly about the dichotomy between 305 and 406. Section 305 is the section that says that special districts have to comply with the land use regulations, but not the land use ordinance. Now we're back to the schizophrenia on the county's part because now they're trying to say it's the other way around. We believe that it's fairly clear that section 305 says that you have to comply with the land use ordinances. The county can't have it both ways. They can't say, well, it's not an ordinance, but you still have to comply with it because it's a general plan. If it's not an ordinance, then, I'm sorry, if the county general plan is not mandatory, then we don't have to comply with it because the code specifically says you only have to comply with the ordinances if you're a special district. What the county is doing is essentially saying you, the special service district, authorized by state law to do this, cannot do your job. The county's ordinance here literally stops KSID from doing its entire purpose. It doesn't make sense to have the ability to have one hand take away the powers that are granted by the state on the other hand. We have the KSID has the power to service. We must be able to build a facility to service it. That service facility complies with the code. It's specifically allowed as a conditional use item. And as we all know, a conditional use is a permitted use with lipstick on it. Lipstick on a pig, to use the old joke, as your thoughtful memorandum explains, as we quote in the brief. A permitted use, a conditional use is presumed to be permitted if any reasonably anticipated detrimental effects can be reasonably mitigated within applicable standards. That doesn't mean you get to make up things that cannot be mitigated. That's again back to why the word objective is in there. So we know what we can do. You can't say, if we like the color or if we subjectively or in our discretion want you to do something. That's not how it works. So we're back to the same argument that circles around through the thread of all the through line, as they say, through all of these arguments. And that is, we are fully compliant with the adopted growth strategy, if there is one, by way of the general plan future land use map. We're protected from the applicability of 406 because of the objective standards, because of 305. We comply. Obviously, our brief talks about public safety and all of those other arguments, and I'm not going to repeat them, but it makes a lot of sense that if you're going to have a development, then you're going to have a need for sewer, etc. So those are the basic arguments. I want to spend just a couple of minutes on the Urrutia case, because as those of us who practice land use law know, almost all cases that go up on appeal are highly factually dependent. I think Mr. Coons would agree with that proposition. I expect Mr. Call, you will agree with that proposition, because we can all read the cases and we can all read McQuillan and the endless footnotes, and we can all read the American law of zoning cases with their endless footnotes. And every one of those footnotes basically says, well, of course, it's under the law of XYZ state and it's under the particular facts, because we all know this. Every state has a different enabling act. Every state has a different common law history of interpreting that enabling act. So basically, almost no out-of-state case has terribly good precedential value. But Urrutia, I believe, is fairly good on one argument, and that's basically that you can't sneak in a vague general plan and make it mandatory and use it as an excuse to operate to do downzoning, because zoning is generally specific standards. It's not vagueness. It's not all the rest of it. So that's the basic holding of Urrutia, and it's found at, we cite it in our brief, page 744 of the decision. I believe it's head note 9, 8 and 9 in the, to use the old citation version, in the hard copy that Mr. Coons courteously provided you with his brief. And as I say, I believe the principle is very clear, and it's fairly analogous, well, it's exactly analogous to what I've said in the other issues. I don't think I have any more of a formal presentation, knowing that, Mr. Call, you've read everything. I don't see a need to do that. My usual practice is to invite any questions, and my guess is, knowing the way you operate, you're going to wait to hear from all three of them, Mr. Call, Mr. Coons, and then me again, and then you're going to ask questions. But I'm ready to take any questions you have now, or I will address them after I've had a chance to respond to the eloquence soon to be forthcoming from Mr. Coons.
Yes, let's go ahead with the county. Thank you.
I appreciate Mr. Baird's overly flattering compliment. And I do want to also just commend him on his suit wearing. I was under the impression he wasn't going to be wearing one today, so glad to see that. I want to address first the new argument that Mr. Baird raised today regarding conditional use permits. Under 506, I'm just going to use the last three numbers of the code. We know we're in CLUDMA, if that's okay. So under 506(1)(a), for a conditional use permit, a county can require compliance with objective standards, and Mr. Baird stressed that those standards must be objective. However, we're not dealing with a county requirement here. We're dealing with state law, a state statute, 406. It's independent of that provision, and therefore 506(1)(a) is inapplicable to the analysis we're doing here today. In fact, if there were a growth strategy at issue here, then that could be analyzed for compliance with objective standards, but as I'll get to, we don't have one of those here today. Underpinning, I think, KSID's argument is really the idea that general plans are simply advisory guides for governmental entities. And state law, in fact, backs that up. Under 405, state law says that general plans are just advisory guides. But importantly, 405 has a very straightforward, clear exception to that rule. And that exception, one of those exceptions, is 406, where a public utility must conform to the general plan. So the general idea that general plans are just advisory guides does not apply when we're dealing with an analysis under 406. And this is primarily why I believe RUSHA doesn't apply here. It's an apposite, because in Idaho, the scheme is similar to it is here in Utah, except that they call their, I believe they call their general plans comprehensive plans in Idaho. But they're, just like here, the comprehensive plan is an advisory guide for political subdivisions that must be implemented through county ordinance. And at issue in Arusha was the county had an ordinance that required conformance with their comprehensive plan. And it only analyzed it, even though the subdivisions in that case were permitted uses under the zone, the county instead denied the subdivisions because it wasn't compliant with or conforming to their comprehensive plan. So there was no statutory exception at issue in Arusha, like there is here. We're dealing with state law. We're not dealing with a county ordinance. So state law requires conformance to the general plan, and that is accepted from the interpretory standard that is just an advisory guide. Turning to the arguments regarding the urban growth strategy, whatever an urban growth strategy is, it's clear that one, it's a strategy, not a zone, and two, that one doesn't exist here. And if we don't have an urban growth strategy, then we don't have a trigger to allow extending utilities beyond service level area 1, which this is not part of. Service level area 1 has already developed utilities, but that is not where we're talking about right now. It still allows development in the HC zone, just not to the level of density or of use that KCPD wants. It was used as camping before. That's a commercial use. It's not high density, but it's still a use, a commercial use of the zone. And the zone itself does not require utilities. That's not part of the definition of the zone. Turning to the deference argument, the deference that Mr. Baird relies on frequently in his briefing, that the general plan must be interpreted to favor the applicant. That is only applicable to land use regulations, and land use regulations is a defined term under CLUDMA. And if it makes no sense, then that needs to be taken up with the legislature. But the legislature defined the term, and if it defined the term as a regulation that's enacted only by ordinance. This was not enacted by ordinance, so then it is not subject to that kind of deference. I want to speak finally about the 305(1)(a) argument. 305(1)(a) is in a different part of CLUDMA than 406. 406 deals with general plans. 305(1)(a) deals with general regulations. And it's addressing a situation where another political subdivision owns property in a different jurisdiction, a county of a different jurisdiction. And it says in that instance, those other political subdivisions must conform with the ordinances of the jurisdiction in which their property lies. Simple enough, not very complicated. It does not, however, contradict 406, which is an independent provision in a different part of the code dealing with general plans. All that 406 does is it adds another layer that utilities, specifically, not special districts, but utilities, special districts that are constructing or using their land for a utility, they, in addition to complying with the local ordinances, must also comply with the general plan. It's a harmonious reading of those two sections, as we know that if there is any sort of contradiction, Utah looks to harmonize potentially disagreeing provisions of statute, and that's a harmonious interpretation that I think has the added advantage of being correct in this instance. KSID's interpretation would render 406 meaningless, in fact, for utilities that were being run by other subdivisions, which is almost always, or at least often, the case, which would really lead to an absurd result. So that's the county's response to the arguments that Mr. Baird raised here. The county has responded to KSID's other arguments, I believe, adequately in the briefing. We are happy to answer any questions you have, and I don't know whether Mr. Stocks has anything to say in addition to that.
I do not.
Thank you. Mr. Baird.
Thank you. And I knew Mr. Coons would be as brief as I am because he and I have already done this before. I just want to address only one of the issues that he brought up, and that is the general plan objective standards issue. And it's what Mr. Coons is saying effectively is that you could put anything as vague as you want to in a general plan regarding utilities, streets, etc., as hortatory, etc., just completely vague, completely discretionary. And somehow, because it's in the general plan, even though the general plan compliance is mandatory and requires objective standards that you can, the CUP requires objective standards, you can ignore the objective requirement because you smuggled somehow, camouflaged all this discretionary stuff into a general plan. That doesn't make any sense. At least it doesn't make any sense to me. The objective standards can't be gotten around simply by burying them in a general plan as opposed to burying them in the conditional use ordinance. The conditional use ordinance says you have to grant the CUP if it meets objective standards. The general 406 says you have to comply with the general plan. Well, to the extent that the general plan is therefore mandatory, it's only logical that the objective standards requirement is pyramided down into the general plan compliance requirements. Otherwise, as I say, it effectively neuters the objective standard when it comes to general plans, which we all know, as Mr. Coons correctly stated, such a legislative construction of getting rid of a key statute or not construing them together. You're supposed to construe them together, and it makes sense to construe them together by saying that the objective requirements of compliance with the standards for CUP flows down to if one of those standards is compliance with the general plan. Otherwise, you can put anything you wanted in the general plan, however vague. Anyway, I don't think I have anything extra to say about it. I agree with Mr. Coons that as Mr. Hall, you did as well. I almost oopsed again. I don't think I've seen an issue as clearly framed and as clearly briefed on both sides without a lot of equivocation or a lot of playing around, other than the schizophrenia that I just referenced. But I don't think there's much there, and I'm perfectly willing to submit it on the briefs subject to the argument with any questions you might have. I never thought this was going to go 2 hours, but I'm happy to have the intellectual discussion about it that will hopefully elucidate anything further if you want to.
Thank you. Well, let me give you a stream of consciousness and invite your help with a couple of key issues. In my opinion, 406 trumps 305. Now, for those that have no idea what we lawyers, land use lawyers who live in a completely different ethereal universe, basically the idea is that the government has relatively wide discretion to impose rules and to write those rules and govern the use of land. And since the courts and legislature have extended that power to local government, the legislature also, and by the way, this isn't just the legislature, but also the Utah Supreme Court and the Court of Appeals have said, understanding that broad power that local government has, once the rules are written, they should be interpreted in favor of the use of land. So they would, if they clearly on their face restrict the use of land, then that's to be the result of the ordinance. But if it isn't clear, if it's ambiguous, or if it basically is beside the point, then the common law unlimited right of the use of property remains. So 305 basically restates that principle. But in this case, we have a state statute, 406, and that one says that if a district wants to operate and to obtain land use approvals in a local jurisdiction, then the land use approvals have to comply with the general plan. So that state statute would apply to a use, whether it was a conditional use or a permitted use, and therefore I'm having trouble going down the road of trying to make a distinction between a general use or a conditional use, or applying conditional use language to what 406 says. Also, the idea that general plans are not regulations, I agree with that generally, but in this case, I would disagree with the county in that 406 makes the general plan mandatory. And let me just quickly read what the definition in the state statute is for a land use regulation. A land use regulation means a legislative decision enacted by ordinance, law, code, map, resolution, specification, fee, or rule that governs the use or development of land. So the county makes a point that the general plan was adopted by resolution, not by ordinance. But in this case, the land use regulation can be adopted by resolution if it governs the use or development of land. And I guess my point is that 406, the state statute that requires compliance with the plan, then vests the general plan in this limited circumstance as governing the use of land. So that distinction basically, in my mind, doesn't help resolve the matter here. As it happens, then I'm down to just a couple of narrow issues, and you both touched on them this morning. So I would appreciate any additional comments. as I understand it from the general plan, there's almost 3,700 square miles of land in Grand County. And I also understand the concept that Mr. Kuntz has explained about trying to reconcile the different provisions of regulations and ordinances and come to some harmonious result. The general plan doesn't specifically say that this specific property has to be subject to an urban growth strategy. It can easily be understood that the provision of the general plan could apply to all kinds of private property throughout the county that are not shown as having any use in the general plan and should not have any specific use until they are part of a comprehensive urban growth strategy. But I'm somewhat persuaded, in light of the duty to interpret regulations, including this general plan as it's now been elevated to the status of regulation, in favor of the use of property by looking at the general plan itself as an urban growth strategy. The intent language of the general plan, found in the general plan, says that's what it is. It's designed to accommodate future growth and to look at how this is supposed to be coordinated. There's extensive work done, not just in the general plan adoption in 2022, but also the update in 2024 by many people. Again, an exhaustive process creating an outstanding 209-page plan with a 29-page update. And so it's easy to construe that as being not just an urban growth strategy, but a profound one. So it may be that the requirement for an urban growth strategy could be then considered as applying principally to those that are not shown as developed in the general plan, that those properties which are not shown as developed would then need to be part of some new strategy that would show them. But as Mr. Baird points out appropriately, page 147, the land use map shows this land used in the 2030 plan. That's just 6 years from now. This plan is that land could be used. So this leads me to the last part of my wandering in the Grand County wilderness here. And that's the point Mr. Kuntz made a minute ago, and that is that it can be developed. It can be developed for the use that's shown right there. It just, that use doesn't require utilities. And so therefore, if that use doesn't require utilities and that use can be placed there, then the question is, back through section 406 of the state code, does the provision of utilities on the property comply with the general plan? So anyway, those are my ruminations. Mr. Baird, would you like to offer any insights? And Mr. Kuntz?
I will. I appreciate that, Mr. Call. And I have listed those 5 things, and I'm not going to try to argue with you about 406 and 305. I think the briefing was clear, and I don't want to waste our precious time on arguing that. I respectfully disagree, but I understand your position. Taking your second point, I completely agree with you about 406 essentially making the general plan a mandatory argument and a land use regulation, and you're correct in your reading of the definition. I do think that if that's the case, then that it logically follows, as I've said before, that those standards must be objective, not subjective. Because if it's a land use regulation subject to 404 interpretation guidelines, then it's subject to 406 objectivity requirements because it has become mandatory. The next thing I'll point out is I agree with you that the general plan, as I pointed out, is in and of itself an urban growth strategy, at least for those properties that are shown, such as on 147, as being urban growth. So the only part I'm going to add to is I believe that the question of what you can do on the ground, whether it requires utilities or not, is defined by the fact that a utility at this time is a conditional use. So we don't have to worry about whether it's compliant with the general growth strategy, that we've got an adopted zone that shows this as highway commercial mixed use. Highway commercial, yes, a camping facility is one of the allowed growth uses there, but it is not the only permitted use. It is not the only conditional use. The growth strategy, by showing it as it does as highway commercial, certainly means they can do way, way, way more things than just the one existing use. And essentially any other use that you could allow in there would by definition require utilities to service it. Therefore, those utilities clearly are within the conception of the adopted urban growth strategy. And therefore, because they're a conditional use and they meet the objective standards of a conditional use, and the county never found any objective standards that we didn't meet. The county simply said, you're a utility, you're not specifically provided for in this growth strategy, therefore you're dead. That's the end of their argument. That's it. They didn't bother to address any other conditions. In fact, every objective condition that staff could think of, we stipulated to. And remember, this staff didn't just stipulate to this once. The staff report twice listed objective conditions, and we said we will meet every single one of those objective conditions. Remember, the staff report the first time didn't even bring up this master plan, general plan compliance issue. The staff report the first time said we're good to go. Only after essentially everybody screamed and hollered did somehow somebody figure out, well, maybe there's this non-growth provision in the general plan that we can smuggle into the ordinance and try to use this non-objective, we get to choose what we want to put here version retroactively as a condition, which there's no objective way to meet that condition. It's either binary or not. And we believe that we've met that condition. So I'm rambling a little bit in response to your rambling, Mr. Call, but I thought your analysis was thoughtful with those two different additions regarding the objective standard, this not being objective, and regarding the other uses that are contemplated in the district, not just camping, and therefore those require utilities. So we think all of those things, your analysis compels a reversal of the decision because of for the reasons I've already articulated.
Thank you. Mr. Kentz, Mr. Stocks?
Yes, just a few comments. First of all, regarding the idea that 406 sort of by dint of requiring conformance with the general plan sort of transforms the general plan into a regulation. I understand what you're saying about the definition under CLUDMA of a land use regulation. However, I think that it's contradicted by section 501 subsection 2, which is the section that says that land use regulations are only adopted by ordinance. So we have, I think, a discrepancy between that section and the definition. And between the two of them, I would argue that 501(2) would control over the definition that was given.
So land use regulations can't be adopted by the state legislature in the form of 406?
I'm sorry, can you say that again, please? I'm sorry.
Well, can a land use regulation be adopted by the state legislature as in the form of 406, which requires that the provision of public utilities conform to the general plan?
I think we still have a problem with 501 subsection 2 if that's the case. It says only by ordinance. It's very specific as to how a land use regulation is adopted.
Okay. And by the way, again, I'm sorry to those observing and trying to follow all this. The question is, if it's a land use regulation, if this requirement that it comply with the general plan is a land use regulation, then my duty as a hearing officer is to interpret it in favor of the use of land, not to stand on my head to do that. but I'm to follow the plain language. And if there's any ambiguity, I'm to interpret it in favor of the use of land. Or if an interpretation of the plain language simply allows for the use of land, then that's how it should be interpreted. On the other hand, if the plain language limits the use, then my job is to follow the plain language and limit the use. So again, thank you, Mr. Kintz, for your help with that.
And just a couple of more issues. I wanted to jump to the final issue you mentioned first, which is that the land can be developed, it just doesn't need utilities. And the question really we have here is just an intensity of use question. And KSID is arguing for a more intense use, and the county is saying no, because a utility can't be placed there. If in the brief that KSID submitted, they said, well, we could do septics, tanks, and wells there, but they said they believed it would be less safe next to the river. In other words, the county interprets that as sort of, well, less safe is code for not as intensive a use or less density. But nonetheless, by making that statement, they are admitting that they could, in fact, build residences there even. It would just be a less intense use. The application of 406 wouldn't prohibit that use, and the county's requirement for an urban growth strategy doesn't stop it either. If you look at section in the policy, and I'm sorry I don't have it the Bates number with me. It's in 6.1. 6.1 policy number 3. Oh, that is, I believe, on page 1610, Bates number 1610, where the county sets forth in its general plan that it is will integrate compatible land uses within the county through specified study and action plans. In other words, if you look at this from, say, a 30,000-foot level, what the general plan is saying is that we are going to have growth, we are going to expand level service 1, but we're going to do it through action plans and study the question and develop a strategy before we implement it. I mean, the county very well could have said in Romanet 8 that we have been discussing, they could have called out general plan. They could have said, according to this general plan, that is how you can trigger additional extension of services from service level area 1, but it didn't. It said, and it capitalized it, urban, actually, sorry, it did not capitalize it. I was reading the urban service area, but it did say an urban growth strategy. It did not say general plan. It could have easily said general plan, and I would argue that the same thing here applies as applies to statutes, that we consider that it was the terms were used advisedly. So something different was meant than the general plan. By its plain language, it meant a different kind of strategy. And because it did, and there is none, then that trigger doesn't apply here. That is the extent of my response. I don't know if Mr. Stocks has anything additional to add.
No, Mr. Koontz covered it.
Thank you. Mr. Baird, any parting shots? I think we're on the short strokes here.
Just one, Your Honor. And again, I'm not sure why Mr. Coons focuses on the you can do something, just not as much as you want argument, because the urban growth strategy says what it is in the plan, page 147, and it doesn't just say camping. I understand he wishes that the county had been more clear, but what's clear here is that the county, by trying to do this, by stalling this process, coming up with this, the CUP, the development application, they tried to do by the back door through this general plan in a method that I'm going to call too cute by half. Tried to find a way to deny the vested rights to the necessity of the development that goes around KSID by going at what they perceive to be the weak link of KSID because of this general plan compliance argument. But even though they tried to do it as cutely as they could, they screwed it up by not recognizing that it has become mandatory, therefore subject to the objective requirements. They screwed it up by having all this red language in it. They screwed it up by having page 147 in it. They screwed it up by saying you have to comply with it, but we're going to make it completely discretionary on our part. Now you have to come beg in the future. So our position is pretty simple. And again, I don't want to articulate it any further. Based on our briefing and the argument today, we think that the decision should be reversed, and we look forward to your written opinion.
Any other comments, Mr. Kuntz, Mr. Stoggs?
I hesitate, but I think it's probably understandable. But the county, this is not some backdoor effort by the county. The county didn't put that provision in its general plan with foreknowledge that KCPD wanted to do its development as some sort of poison pill to be activated at years in the future. This is a legislature requirement in the form of state law, and the general plan states what it did without anticipating this development. So I just wanted to take issue with the characterization that this is somehow the county through probably prophecy planning for this eventual development.
If I may respond for 30
Sure.
seconds, and that is, it's not prophecy. The actual application for the surrounding development had been in for 2 years before anybody potentially even raised the sewer service issue. And at the meantime, some clever people were working behind the scenes to find this back door. I don't think it matters. And I didn't expect Mr. Kuntz to stipulate that I was correct in the county's Machiavellian nature here. I'm not sure that the Machiavellian nature here is actually terribly relevant to the legal question, which has been thoroughly articulated by both Mr. Kuntz and I, and by yourself, Mr. Call.
All right, thank you.
Mr. Call?
Well, yes, please.
I don't know from your position if any of the things that we've discussed further, if you'd like more information on. I know the argument regarding the use of or viewing the general plan as the urban growth strategy. If you'd like to delve more into that topic or would like supplemental briefing, the county would be happy to do that. But if the hearing officer does not feel that's necessary, we're fine to submit.
I think we're fine.
I don't think it's necessary. I think the issue's been well raised, and I'm not prepared to make a decision now because you have prompted me to want to go back and review the general plan again, not just looking at this section 8, VIII, but the context around it. So you prompted me to do that, and I certainly want to do that before I make a final decision. So I will take the matter under advisement at this point. I appreciate the courtesies extended and the, again, thorough briefing and articulate discussion today. I would expect to have a written decision available and the matter concluded within a week. Any other questions or comments about that?
Thank you as always.
Thank you.
Thank you.
That will complete our business today. Thank you.
Thank you.